Hi, everyone, and welcome to this week's episode of Law Chat with John and Amy. I hope you had a good week. I'm John Yulian.
And I'm Amy Poliafico. This week's question is, what happens if I fall behind on my Chapter 13 plan payments? And just as a reminder, a Chapter 13 payment is a repayment plan. You have to make payments to the trustee every month for some time period, typically between 3 and 5 years. And those payments are due monthly, and sometimes life happens and you don't get it out or you can't afford it that month. So we're going to talk about what happens when you're behind today.
Sure. And Amy, what I think people need to remember is if you're a week behind, 2 weeks behind, 3 weeks behind, that's really not going to cause some type of action by the Chapter 13 trustee. Ideally, you're making one payment each month as you're required to do. You fall 1 month behind, well, you might want to speak to your attorney. Certainly at 2 months behind, you should be speaking to your attorney so the attorney understands what was the cause of your falling behind, and is that something you'll be able to correct within a reasonable period of time. So
But
sometimes, oh, sorry, Amy, go
I
ahead.
just wanted to say, like, occasionally I'll get a phone call from someone on like the 28th of the month that's like, it's been hectic. I'm just mailing out my payment today. The trustee won't get it till like the second or the third. Is that going to be okay? And 100%, that's never going to be an issue. The trustee's always going to give you some kind of grace period. And I just hate those phone calls because everyone is so stressed by the time that they're calling me about it. And just like that, don't stress about that. That's not something to worry about.
No, it's a good point. I think what is more significant is as you fall further behind, 2 months behind, maybe 3 months behind, you really need to be speaking to your attorney to find out what options there are to address the arrears. Meaning, well, I got a couple months behind because I had some unexpected expenses. I can get caught up within 60 days, or maybe it's I had a decrease in income because I'm seasonal or didn't have overtime that I usually have, but once again, I can get caught up. So those type of things can be corrected.
Mhm.
A plan can be modified if for some reason circumstances have changed. So there are ways to address it. You don't want to put your head in the sand and ignore it. That really is the worst way to go about it. Amy, maybe you could talk about actually what happens when the creditor files, not the creditor, but the trustee files a motion to dismiss because someone has gotten behind.
Yeah, so the trustees review cases, and if you are behind, they can file a motion to dismiss for failure to make your plan payments, which is a violation of your plan, which essentially is a violation of the court order. And I'll say typically, most of our cases are Boston-based Chapter 13 bankruptcies. And so generally sometime around the 20th to the 25th of the month is when we're going to get our motions to dismiss on anyone who's behind that month. So if you get your motion to dismiss, you're generally not the only one that month. So maybe that will make you feel a little bit better. What I do when I receive our motions to dismiss is I immediately go to the trustees information website, which is the National Data Center website. National Data Center. I just said that with such a Boston accent. And so and I print out a record of every payment that you have made to the trustee, and then I'm going to send you a letter saying, here's the motion to dismiss, here's your payment history. Please look at it, make sure every payment is accounted for. And maybe you thought you had made a payment and you hadn't, or whatever it is. And then I asked you to give me a call. The most important thing you can do is call your attorney, because if you don't, I can't oppose a motion to dismiss and your case will get dismissed. So please give me a call. We can figure out something, whatever it needs to be. Often what happens is someone is like you said, an unexpected expense came up or your income was lower than you expected. And to most people are like, I need 60 days, I need 90 days to get caught up. And in that case, I would file an opposition to the motion to dismiss. The court would schedule a hearing on that motion. And hopefully prior to the hearing, I could enter into an agreement with the trustee that says, here's when they're going to get caught up. And then we wouldn't need a hearing. And as long as you do follow the timeline that we have agreed to, we won't have an issue.
And Amy, what about the debtor who calls up and says, I can get back current, but it's going to take me 12 months or maybe 18 months to do so because I have to start making my regular payment and I need that extended period of time to really get current again because it's a lot I'm paying.
Yeah, so the trustee is never realistically going to agree to give you that much time in an agreed order. But if you're that far behind and the payments are that out of control, but you somehow think you can manage to pay a little bit more than you're currently paying, it might be time to look at an amended plan because clearly your income and expenses are not what they were when we filed your original plan. So if that's the case, it's probably someone who I'd say, hey, come into the office, let's go over this income and expenses, figure out where we are. And there are times when I can amend a plan and roll the arrears in and then and continue to pay them over the length of your plan. It just depends on the situation and if it was like a one-time blip or this is an ongoing change in your income and expenses.
And I think that gets back to the point both you and I were making that it's critical you reach out to your attorney when you fall behind to see what your options are and the best way to deal with the situation. Just because you miss a payment doesn't mean your case is automatically getting thrown out. There are options and ways to address it.
And I will say
anything else? Yeah, you want to add
just one more thing. I think sometimes people are realize like, oh my God, I've missed 2 plan payments. I shouldn't even bother to send this payment because like I'm already so far behind. But I would say one of the requirements to be in a Chapter 13 is that you're making regular payments, and the trustee, if she does file a motion to dismiss, in order to get her to agree to give you more time, she's going to want to see that you've made at least one recent payment. So even if you can't send a full payment in, send something in. It shows that you're trying. It shows good faith. And I would say that.
Yeah, it's a very good point, Amy. Maybe a good point to finish up today's discussion. So I hope that was helpful to everybody.
Thanks for joining Law Chats with John and Amy. We look forward to chatting with you again next time. If you have a question or comment, feel free to email us at info@yulianlaw.com. Remember that Law Chats with John and Amy is intended as a general reference and considered general advertising, and listeners should check for changes to any applicable laws and consult with an attorney on any legal issue. The information provided does not constitute legal advice, and any thoughts or commentary by the podcasting lawyers is provided as a service to the community and does not constitute solicitation of legal advice. The lawyers in the law firm of Yulian & Associates PC make no warranties and disclaim all liabilities for damages resulting from its use. Nothing provided in the podcast should be considered a substitute for advice from counsel. No attorney-client relationship is formed by listening or participating in this podcast, and in the event that the podcast receives emails about the subject matter, no attorney-client relationship is created via the email communication.